Hello everyone and welcome back to Rajput, Jain and Associate. Today in this video we will discuss about the changing the name of a company with ROC. A company's name is the title by which it is recognized across the world. Thus, a company's name may be altered over time to meet the demand of the company. Now we come on to some of the prerequisites of company's name change. First one is where a company wishes to change its name, it must file their annual return or the financial statement with the registrar of companies on or before the prescribed time period. Secondly, a change of name is permitted on the submission of required papers or the repayment of maturing debentures, deposits or interest thereon as may be applicable. Now there are certain things that doesn't get affected when a company undertakes change in name. Firstly, the rights or the obligations of the entity will be unaffected by the change of name as well as any legal procedures that are brought against or by the company under its previous name. Also, when the ROC registers the new name, any new legal procedures brought against the corporation in its own names are invalid. The entity should be regarded as it is never existed under its previous name. However, by modifying the plea, the name can be substituted. And lastly, the company's legal processes that were started under its previous name can be resumed under the new name as well, since the name change does not affect the constitution of the company. Now we will discuss about the procedure for change of name of the company. But before discussing about the procedure, we will discuss about the condition for getting the prior approval in the process of changing the company's name. So for this, the board of directors of the respective company would be required to pass a resolution for changing the name of the company. Then, the approval of the shareholders be obtained and the resolution shall be passed by a special resolution. After this, ROC's approval would be required in the form MGT 14. And lastly, the central government's approval would be required in form INC 24. Now, having discussed about the prerequisites for changing the name of a company, we now come on to the step-by-step process to alter the name of a private limited company. Firstly, a change in the company's name involved a change in the Memorandum of Association. A Memorandum of Association or MOA is a charter document that contains everything from the name clause till the object clause in the formation of a company. A change in a company's name prompts a change in the name clause in the MOA as well. As a result, the firm must follow the procedure for changing the MOA that is outlined under Section 13 of the Companies Act 2013. According to this section, the company's name can be changed by adopting a special resolution with the consent of the central government. Then, certain important things to look for when changing a company's name is: first of all, before undertaking name change, be assured that the company has filed its annual return, filed its annual financial statements with the registrar of companies, the interest on the matured deposits or debenture has been duly paid or has been returned. After that comes the conducting of board meeting to discuss the company's name change. A board meeting must be called in accordance with the provisions of Section 173 of the Companies Act and Secretarial Standard 1 in order to consider the company's new name. The board of directors in such a meeting must debate the grounds for the company's name change, recommend two new proposed names, make a declaration on the filing of annual reports or financial statement as well as the payment or repayment of maturing deposits, debentures and the interest thereon. And lastly, allow one of the company's director or the company secretary to file a name change application with the registrar of companies. After that comes the request for the new name change availability and name reservation. On behalf of the entity, the authorized director or the company secretary should submit a Run-if online form to the MCA portal together with two recommended names and the requisite fees. A copy of the board resolution must also be attached to the said form. ROC will accept the name if all the relevant papers are submitted and the said name are available in the MC records. And in case of any objection, the applicant will be given one pre-submission opportunity to apply for two more new names during a 15-day period from the date of receipt of notice. Next step is obtaining the consent of the shareholders. So after receiving the name, the corporation should seek shareholder approval as well as the central government's permission. An extraordinary general meeting shall be held for the purpose of shareholder approval by issuing notice to all the interested parties and marking the attendance of the minimum number of shareholders. Following that, shareholders' approval will be sought through the passing of special resolution, which shall be subject to the approval of the central government. Within 30 days after the passing of resolution, the special resolution shall be filed with the registrar in Form MGT 14 along with the attachments such as the certified copy of the special resolution, the EGM notice, an extraordinary statement to the EGM, a changed memorandum of association, and lastly a changed article of association. Now once MGT 14 is filed with the registrar of companies, the entity is required to file Form INC 24 with the registrar of companies together with the requisite fees in order to obtain the central government permission for a name change. After that, the next step is obtaining the central government permission. So as previously discussed, suggested name should not be identical or similar to the companies that are already in existence or otherwise shall not be undesirable in the eyes of the government. Now once Form MGT 14 is filed, Form INC 24 must be filed with the registrar of companies to obtain the central government approval. So for filing Form INC 24, some documents to be attached include, first of all, an explanation should be sent to the shareholders for their approval. Then a true and certified copy of the special resolution passed shall be attached. Then the changes to the MOA and AOA should be provided. The general meeting minutes should be attached, and lastly the director's affidavit should be supplied with. After this is the issuance of new certificate of incorporation. So the registrar on receipt of the documents will scrutinize the same, and if found correct, the registrar of companies will issue a new certificate of incorporation to the company in its new name. Now after name change, there are certain requirements which the company is required to comply with. The business name must be inserted in all the copies of MOA and AOA once the new certificate of incorporation is obtained from the ROC. The corporation must alter its name in all its business communication along with the boards and the seal of the company location after the new name has been registered. Apart from this, the entity must submit an amendment application as required under the governing statutes like the Goods and Service Act, the Shop and Establishments Act, the Factories Act, the Foreign Exchange Management Act, Private Security Agency Act, Interstate Migrant Worker Act, EPF and ESI Act, other labor laws and industry specific laws. So this was all about the change of name of private limited company. For more queries, contact Rajput, Jain and Associates, or you can also visit our website www.carajput.com. Thank you.